Oh, veterans, DKV employees, everybody watching. Hey, welcome to the channel. As always, I'm your friendly VA credit attorney, Matthew Lang, here with another educational topic about VA disability. So let's talk about it. Before we talk about it, though, veterans, always remember if you need help with filing a claim, new claim, your first one, just a new one after you filed a claim before, a claim for increase, an appeal of any sort, from the supplemental claim level all the way up to the Board of Appeals. Just know that you can reach me at veteranlang.com. You can get to my calendar there and schedule some time, either for a phone call or in-person VA case evaluation. Free of charge. There's no admission at the door here. We're not that kind of club. So we'll sit down with you and we'll talk about your case and see if we can do anything for you and what we can do, and we'll take it from there. Don't forget also. You have VSOs, you got other accredited agents and attorneys out there to help you out, veterans. So if there's somebody that you would like to get the assistance from that's not me, just remember they're there. They're there to help you out. So thinking of assistance, let's talk about this duty to assist some more. Duty to assist. I know we've talked about it before in some other channels. We've talked about some of the errors and stuff, but today I want to hop in my DeLorean here, make sure my flux capacitor is working. Maybe I'll take Doc Brown and Marty McFly on a ride with me here. And everybody else, jump on in. Let's take a trip through history and understand duty to assist. Let's understand where it came from and where's it at today. Now, I like to do this when teaching things because I always feel that understanding where we came from and where we are today helps us to improve the future. So let's give it a shot. Make sure my notes are in the right spot. My apologies for that long pause there. Here we go. We just leave bloopers in here. I'm not perfect. So there's an old rule before duty to assist came out. Now we're going to talk about it here. Duty to assist came out in 2000, as we know it today. It was known as the Veterans Claims Assistance Act, VCAA for short, and I'll restate that later on here. But I want you to understand that before the VCAA, the old version of 38 USC said that the claimant had the burden of submitting evidence sufficient to justify a belief by a fair and impartial individual that the claim was well grounded, as it was called. And only then did the VA's duty to assist kick in. This meant the veteran first had to bring enough to the table to make the claim look plausible before VA had to help gather records, help develop facts, or help move the claim forward. In plain English, I would say veterans, what they were telling you is prove enough first, and then maybe they'll help. Now, the threshold mattered. A claim could be shut down early, not because it was fully disproven, but because it was deemed not well grounded at the outset. So I've seen a lot of these. I started VA in February of 2008 originally, so VCAA was still really young at the time. It was like a child still, adolescent perhaps at this point. So we've still seen those older decisions in the 90s come along and seen how things were denied for not being well grounded. It was really sad to see, honestly. So VCAA took a step forward for the veterans. But before we even got that far, we had to have some court cases really highlight, well, the problem and get Congress's attention. One of those major cases that's associated with this era is Morton v. West. So that case, the court stated that under 38 USC, absent the submission and establishment of a well-grounded claim, the VA, or the secretary, could not undertake to assist a veteran in developing the facts pertinent to the claim. So ultimately, it was like the court was saying that the VA was right in denying because the law said, well, the veteran didn't bring enough to the table. The veteran didn't prove their burden. Well, the rule became a flashpoint. Well, why? Well, I think you kind of got the idea, but it was because it highlighted the harsh reality of the old system. Veterans often needed help to get the very evidence required to make the claim well-grounded. but VA could refuse to help until the threshold had already been met. VA was really kind of being kicked to the curb in a way by the same agency that, well, was there to help them out. So the Morton case did not create the problem out of thin air by any means, definitely not. It exposed it even more than it already had been. It brought the tension out into the open and made Congress confront the system that could deny assistance at the front end of the process. So this is where the Veterans Claims Assistance Act of 2000, or again often known as VCA, came about. Congress expressly amended Title 38 to reaffirm and clarify VA's duty to assist veterans and claimants. The VCA did something enormous at this point. It removed the well-grounded claim requirement from the Title 38 USC, and it replaced that old burdened language with the modern rule that a claimant has the responsibility to present and support a claim, while VA carries defined statutory duties to notify and assist. So it's almost like it was supposed to be a team effort. Veterans, you still have some responsibilities to provide evidence, but VA could no longer just deny you for feeling like you didn't provide enough evidence for them to help out. VA still had now a statutory duty to notify and assist when you provided the claim. This was a pivotal point in modern veterans law. The question stopped being, has the veteran done enough to deserve help? You would think the service to your country was enough to get help. But it ultimately became much more like, what reasonable steps must VA now take to help develop this claim? So again, as soon as the claim is filed, what does VA got to do to help? That's the ultimate question. Now, Congress didn't just change the rule going forward. They, for as I understand it, gave some assistance to a few claims going backwards too that got caught up in the well-grounded while the law was getting passed. They do tend to do that with some laws, which is nice. They put in some additional stipulations in there. So under today's 38 USC, VA must make reasonable efforts to help a claimant obtain evidence necessary to substantiate the claim. Now, that's going to include things like obtaining relevant service records. So veterans, as you probably already know if you've been through the system, and if you haven't, when you file your first claim, VA is responsible for assisting you in obtaining your service treatment records, for example, and perhaps even your personnel records. The system should automatically trigger, in all of the technology we have now, to pull those across from archives, if that's possible, depending on the era that you served. So they now have a duty to obtain those records. You don't have to find those on your own and give them to them. Now, they also have to pull over relevant VA treatment records. That means they've got to go check their databases. They got to see if you've had any treatment at a VA healthcare facility. And if you have, they've got to pull those records. That's part of their duty to assist now. They've also got to pull other federal records that are relevant to the case that have been adequately identified. So veterans, if you perhaps identified, say, treatment at a military installation after service at one of the hospitals there because you received TRICARE or you're retired from service or whatever the case may be, then those are federal records that the VA is going to have to assist on. Now, keep also in mind, maybe you receive a Social Security disability benefit and you identify that, well, that's a federal record as well. So now VA's got to assist there too. But now, we don't just stop at the federal records. This also includes helping with private records. So veterans, when you adequately identify those private records, and when I say private, we're talking about outside of the federal government here. If VA cannot obtain them after reasonable efforts, VA must notify the claimant what it could not get, what efforts were made, and that the claim may be decided on the evidence of record. So in disability compensation claims, the duty to assist can require VA to provide medical examination as well. It can also require medical opinions when one's necessary to decide the claim. So this is one of the most important evolutions in practice. Today, development is not supposed to be a passive waiting game. VA is not supposed to sit back and say, come back when your file is perfect or well-grounded. The law requires active, reasonable assistance. Now, keep in mind, veterans, that doesn't mean they got to assist you on everything. There could still be things that you're required to do and help with as well. Now, VCAA did not only expand the duty to assist, it also strengthened VA's duty to notify underneath the 38 U.S.C. So VA must tell the veteran or the claimant that and the representative, if they have one actually, what information and evidence is needed to substantiate the claim, what the claim is expected to provide, and what VA will attempt to obtain. Now, this matters because the modern system is supposed to be more transparent, at least on paper. The veteran should not be left guessing about what is missing and who is responsible for getting it. Yeah, I'm pretty sure I just heard a bunch of grumbles there. I hear you. We'll get into that. So when we talk about the VCA, we are really talking about two major protections that are supposed to be working together. Notice and assistance. The duty to notify and the duty to assist. Now, even after the VCAA, the law kept evolving. We've seen it, right? Law continues to evolve all the time. One major example was the McClendon v. Nicholson case. So in this case, the court emphasized that when deciding whether VA must provide an examination, the requirement that the evidence indicates a disability may be associated with service is a low threshold. Just has to be the lowest possibility, any inkling that a disability may be associated with service. It's a low threshold. So this is a big deal. Well, it means veterans do not necessarily have to fully prove nexus before VA gets an exam. If the evidence reasonably suggests a possible connection and the record is still insufficient to decide the claim, the duty to assist may require development. So over time, the duty to assist evolved from almost a locked door under the well-grounded framework into a broader development obligation that, at least in theory, is supposed to help the veteran get a fair decision on a more complete record. Yeah, I heard some more grumblings, I'm pretty sure. We'll talk about it all over time, but just understand this is what it was supposed to do. Now, again, let's be clear, the duty to assist is important, but it's not unlimited. No law is unlimited. The statute still says VA is not required to provide assistance if there is no reasonable possibility that the assistance would aid in substantiating the claim. The law also expects the claimant to present and support the claim. So the system is not VA builds the entire case for you, veterans. The system is supposed to be the veteran identifies the claim and relevant evidence, and VA then takes reasonable steps to help develop that claim. Now, this distinction matters because many veterans may hear duty to assist and assume VA will chase every theory. Maybe obtain every record. Maybe fix every weakness. So in real life, VA often does less than it should. And even when it does act, the legal obligation is framed by reasonableness, relevance, and timing. So the next major evolution came with the modern review system of the Appeals Modernization Act. So as our DeLorean continues moving here and the flux capacitor keeps holding, we find that under the current 38 U.S.C., the duty to assist applies to a claim and a supplemental claim. Up until notice of the agency of original jurisdiction decision. So when VA renders that decision on your supplemental claim, veterans, or that new claim or original claim or claim for increase, that's where the duty to assist applies up to. The statute specifically says that the duty to assist does not apply to higher level review or board review in the same way. So we're not saying they don't apply to the higher level review or the board, but it's not the same way. Now, this does not mean duty to assist errors just disappear. If a higher level reviewer identifies a pre-decisional duty to assist error, so a duty to assist error that existed before the decision was ever made, which would likely make the decision premature, then the claim must be returned for correction and readjudication. Now, the higher level review doesn't have the authority to make that correction on their own, so veterans, what you see is your claim goes back down to the supplemental claim lane in order to have that duty to assist error corrected by whichever development is necessary. Typically, a VA exam or medical opinion, in my experience, anyways. Now, if the board identifies a pre-decisional duty to assist error, it must remand for the correction. So they'll call it a remand instead of a duty to assist error, but ultimately, same thing. Claim now has to come all the way back down to the VA in the supplemental claim arena in order to have that duty to assist error corrected. So this is why in modern practice, you'll often hear the phrase pre-decisional duty to assist or duty to assist error. In other words, the question is not simply whether VA failed to help. The question is whether VA failed to help before the decision occurred that's being reviewed. So the duty to assist still matters deeply today, but its procedural role has changed depending on what lane the claim is in. Why does all this history matter? Well, it's because it explains why VA law is supposed to be more, veteran or claimant friendly than ordinary, civil litigation. Again, non-adversarial, and we've talked about that before. The modern system recognizes that many veterans do not begin with a polished file, complete medical opinions, perfect record gathering, and neatly labeled theories of service connection. The VCAA was Congress saying, in effect, we are not going to keep using a front-end technicality to deny help before the veteran has a fair opportunity to develop the claim. And yet, the practical fight did not end in 2000. Today, many of the same battles simply show up in a different form. Failure to obtain records, failure to provide an exam, inadequate exams, probably the number one issue for a number of years. Poor notice, blanket letters to CYA themselves. That's what we were taught to do. So veterans, you'll get these letters, and I know the ones we assist will bring them to us and go, what's this? Yeah, it's just VA slapping everything down on the letter saying we need all this, even though we have half of it, just because they feel like they need to CYA themselves. That's just the reality of it, unfortunately, from what I've experienced. So VA, just remember, duty to notify doesn't mean just slap everything on a piece of paper. It's supposed to be transparent, remember? What are you looking at? What does the veteran need? Not what's everything that they're allowed to ever possibly file in the life of the claim. And then again, there's decisions issued before proper development is complete. We see that quite often. We see that is the biggest reason for duty to assist errors or remands from the board. Things weren't done properly. So ultimately the vocabulary changed. The law improved, but the advocacy is still necessary because, as we see, multiple mistakes happen and it feels like still a well-grounded claim and the law is not interpreted correctly. Hence why you get individuals like me out here, veterans, fighting for you and helping you with your claims. So let's do a little closing here, a little takeaway. Before I get too much on my soapboxes that I told you I'd stay off of this year. Just a reminder to myself every time. The old rule asked whether the claim was well-grounded before VA had to help. The modern rule, created by the VCAA, puts real statutory duties on the VA to notify the claimant or veteran, help obtain relevant evidence, and provide an exam when the legal standard is met. Now, we do see errors on that a lot too. Again, the inadequacies of them all. Veterans, I know you probably feel, why am I doing my third, fourth, or fifth exam when I've already done 4, 3, or 2 other ones? And so we do see a lot of abuse there when it comes to duty to assist. But the VCAA was still one of the most important shifts in veterans' disability law in the last several decades. It did change the starting line. It changed the government's obligations. And it gave veterans stronger tools to challenge bad development and bad decisions. That it really did. So when you hear the phrase, veterans, duty to assist, do not treat it like a slogan. VA, don't treat it like a slogan. You too. When you hear duty to assist, don't treat it like a slogan. It's a legal doctrine with a history. It was shaped by an older, harsher system pushed into reform by the failures of the well-grounded era, and it remains one of the most important protections veterans have in the claims process today. And that is exactly why knowing this history, well, makes you a stronger advocate for yourself, veterans, for other fellow veterans, makes you, again, that better claimant, and makes it much harder for the VA to, well, ignore. How much they may try, we'll appeal them all day long, because those are the rules. Those are the rules. Well, I hope you liked the video today. I think the DeLorean's come to an end here. I don't know if I've got enough banana pills and stuff to throw down into the gas tank. I think that's what it took, right? It's been a while since I've seen those videos or those movies. But yeah, I think it was a fun ride. I think it's really important, as I mentioned at the beginning, to see the history of it all. And I think it's also fascinating in a way when you look at the idea of well-grounded, how you kind of see that mindset is still really into play in a lot of claims today, despite the protections and the rules. So veterans, if you feel that when you look at your claim, VA failed that duty to assist, don't forget, you got representation that can help you out there, accredited representation at that, including myself at veteranlane.com. As always, I'm happy to continue educating. We will continue doing that. I'll see you on next Tuesday when we post another video. And if you ever have a topic you want to learn more about, feel free, throw in the comments, and I will do my best to put together a video and explaining it in more detail if it's a topic we've already talked about, or if it's a new topic, I'll do my best to explain it from the start. Let's not let my experience go to waste. I want to hear from you too, veterans. I know you have a lot of knowledge out there, a lot of research that many have done. Feel free. Share your education as well. Let us help each other in the end and make this process smoother for everybody. Thank you again. I wish you a wonderful week. We'll see you next Tuesday.